I think we're on now. Okay. I'll turn off the music. That's Cafe Accordion Orchestra. There's some friends on. Or used to be. Anyway. This is online module 6B, and we're still talking about things that change after an estate plan is in place. And this time we're focusing on things that beneficiaries can do. So what kinds of things can beneficiaries do? Well, disclaimers, which you all know about from the last Skills and Values exercise. So we'll look at disclaimers and what effects that has. And then sometimes beneficiaries do bad things. So I think that's in the next video. So this one will just be about disclaimers. Okay, let's take a look at Estate of Holden on page 245. I hope you read it. William Holden died intestate. Now I want to specify and make it very clear, this is not William Holden, the Academy Award winning actor. This is a different one who I couldn't find anything interesting about. Okay. In South Carolina, this is another piece you need to know, the spouse only gets half if there are children. So in South Carolina, if you left children, spouse gets half, kids get half. Or issue, not children, issue. The statute refers to issue. So in this case, the wife, Julia, gets half, and then there were two sons, William Jr. and Robert, and they would get the other half. Now, William Jr. also had a child, Zachary, and shortly after his father died, William Jr. had a daughter, Julia. Okay, anyway, William Jr. and Robert wanted Mom to get everything just like she would in a UPC state, so they disclaimed their interests. So we know the general rule is that the disclaimant is deemed to have predeceased the testator. Okay, so here's their family. All right, here's William Sr. is married to Julia. They have the two sons, William Jr. and Robert. And then here's William Jr.'s two kids, Zachary David and Julia Lynn. Now, if William Jr. and Robert had actually predeceased William Sr., who would get what? Right. Now, under South Carolina, remember that the statute says half to spouse and half to issue. It does not say children. It says issue. Okay, so actually, under the intestacy statute, Zachary David and Julia Lynn get half, right? The half that would have gone to William Jr. and Robert. If those two aren't there, then these folks still get half because they're still issue, right? So half goes to grandchildren. Now that's not actually what the boys wanted, or the men. They wanted Mom to get it all. So, you know, they both had executed disclaimers thinking that's what would happen. But once that's done, it's too late. They can't just revoke that. Why? Because the court appointed a guardian ad litem for the grandchildren. Right? The grandchildren now are entitled to half the estate. So somebody's got the job now of making sure that those grandchildren don't lose their interests. So we end up with three. I think this court, let's see, this case starts in the probate court, and then it goes to a district court, and then I think a circuit court, and then a court of, probate court, circuit court, court of appeals, and Supreme Court in South Carolina. This is a lot of litigation. Now, among other things, a disclaimant cannot direct the proceeds, right? You can't say, don't give it to me, pay it to so-and-so instead. So even though William and Robert wanted the shares to go to their mom, they couldn't actually do that. That's not really what they did. So they did say that was their intention in a letter, but that's not the same as actually directing the proceeds. And so that doesn't invalidate the disclaimer. They tried to argue that their disclaimer was invalid. The court says no. They said, that doesn't work. And they said, but it was a mistake. We thought it would go to Mom. That doesn't matter either. Mistake of law doesn't matter. We've seen that before. The disclaimer was based on all the right facts. and they just had bad advice. Really kind of embarrassing for us, the legal profession. But that's kind of too bad. They're a little bit stuck with that. Now, some takeaway points from this. Read the statute, people. Read the statute. These clients or lay people don't make disclaimers. Clients make disclaimers, right? People who have advice, who have someone telling them to do it, disclaimers affect property interests. And if we don't read the statute first, if we kind of shoot from the hip and say, oh, you're treated as if you predeceased the testator, and, and that means if there's no children, it all goes to spouse, read the statute. The statute said issue. Okay, next thing. This statute, and I think I mentioned this here, this statute, the South Carolina statute, incorporates the Internal Revenue Code definition of a qualified disclaimer. That's in section 2518. It's part of the gift tax. That definition doesn't apply if a statute doesn't incorporate it. So you can't just go by that, right? You've got to look at the state statute, and you've got to look at the tax statute if you need the tax benefits. So to get the property effect, we need the state statute. To get the tax effect, we need the Internal Revenue Code. But you've got to read the statute. Please, please, please promise me you will always read statutes. Okay, let's take a look at a problem from your book. This is on page 252. Here's Don and his estate. I'm going to take myself out of this. Don had two kids, Art and Betty. Betty has predeceased her father. Art's got 3 kids. Betty left 1. So how will Don's estate be divided if Art disclaims? Well, now, if Art is merely treated as having predeceased Don, then since Don left no spouse, we distribute the disclaimed interest to Don's descendants by representation. And we know from 2-106 that means we divide at the first generation with living survivors. As opposed to dead survivors, right? The first generation that has living representatives. Well, Betty is already dead, and we're pretending now that Art also is. So that first generation is the grandchildren right here, right? So we're going to divide at that generation, and we distribute that disclaimed interest, that half, to those 4 grandchildren. So that means Bill gets the half he was already getting, and Art's disclaimed interest, his half, will go to all 4 grandchildren. So Art's 3 kids each get an 1/8, and Bill gets another 1/8. Good to be Bill. That's probably not what Art was going for. But let's see if that's what the statute actually does. Here's UPC 2-1105. It's on page 250 if you want to look at it in your casebook. The disclaimed interest passes according to any provision in the instrument creating the interest, providing for the disposition of the interest, should it be disclaimed or if disclaimed interest in general, right? The disclaimed interest passes to any provision in the instrument for disposition of an interest if it's disclaimed. In other words, if the will or trust or whatever it is says something about what to do if there's a disclaimer, that's where we go first. Now notice I skipped a couple of provisions. I jumped in at B2. If you look at the ones before that, it's because they don't tell us how to dispose of the property. Okay, Don, however, died intestate, so this rule doesn't do it for us. All right, if the instrument does not contain a provision, it's described in paragraph 2, good, then here are some other rules. A, if the disclaimant is not an individual. Oh, wait. When would the disclaimant not be an individual? When it's SpongeBob, when it's a trust, or when it's a corporation, or any other entity that is not an individual. Okay, we can ignore this one though, because Art, I can tell you Art is an individual. Okay, so if the disclaimant is an individual, then except as otherwise provided in C and D, the disclaimed interest passes as if the disclaimant had died immediately before time of distribution. Okay, here's our general rule, right? We distribute that disclaimed interest as if the disclaimant had predeceased, in this case, the decedent. Notice that we've got that time of distribution language. That makes it fit any kind of situation, but our time of distribution is decedent's death. Okay, that sounds like the rule we had already worked out, but we didn't look at the exception yet. Except as otherwise provided in subparagraphs C and D. Always go look at those. We don't know what they say. I mean, they might say something totally goofy. They may not apply at all, but we've got to check. Let's go see. Here's C. Okay, if by law, like statutes, or under the instrument, the descendants of the disclaimant would share in the disclaimed interest by any method of representation, had the disclaimant died before time of distribution, then the disclaimed interest passes only to the descendants of the disclaimant who survived the time of the distribution. All right, let's take a look at this bit by bit. First half. If by law or under the instrument, the descendants of the disclaimant would share in the disclaimed interest. And notice, by any method of representation, had the disclaimant died before the time of distribution. Well, we already saw that that's true. Art's kids will share in the disclaimed interest if we just pretend that he died. So this seems to apply. Okay, if that's the case, then the disclaimed interest passes only to the descendants of the disclaimant, only to Art's kids, and only to the ones who survived the time of distribution or who survived on. Okay, so Art's half goes only to his 3 kids. And we should check that other exception, D. If the disclaimed interest would pass to the disclaimant's estate, no, not our situation. We know that it would have gone to all 4 of those kids and not to Art's estate. So where does that leave us? Art is treated as having predeceased on, and Art's share goes to his descendants. So his 3 children each get to split the half, and that means they each get 1/6. And Bill still gets the half he was already getting. So how does that look to you, right? Is that what you think Don probably would have wanted? You know, I think it looks pretty good, actually, because if Betty and Art had both predeceased Don, probably he would have wanted his grandchildren treated equally. But since Art actually survived, probably Don would want to split his estate in half between Bill, or Betty, and represented by Bill, and Art. And so in the case of a disclaimer, I'm comfortable with this. Okay. All right, I think that's it for disclaimers. So first thing, they change property interests. All right, read the statute before you recommend this to anybody. I'm not saying don't do it, but know that it really matters. You can't always undo it. General rule, and this is only a general rule, is that we treat the disclaimant as having predeceased the decedent, but be very, very careful, especially with disclaimers in families. There may be a different rule when there are descendants, and sometimes it's specifically when there are descendants of the decedent, and sometimes it's descendants of the disclaimant. So be very careful when there are descendants. And then notice that in both of those words, disclaimant and descendant, the people are ants. And that is Adam Ant there, a cartoon character from my childhood. Okay, that's the end of Module 6b. Module 6c is very short, and it has to do with misconduct on the part of a beneficiary. Okay, thank you for watching. Talk to you later.